Hi, good evening, everyone. To those of you who are early, I'm going to wait just a few more moments for some persons that may be running behind time. So we can start in about 5 minutes. All right, good evening, everyone. I am Sophia Bryan. Welcome to our estate planning masterclass. We should be here for about an hour or so. If you have questions throughout the presentation, feel free to put them in the chat, or if you want to share your questions audibly, you have the option to do so as well. All right, so I am about to go ahead and share my screen. Think I've given given a bit of time for enough persons. I'm sure persons will hop in as we go on, but we can't stay here all night, of course. All right. If you had any preliminary questions that should have been shared in your in the reminder emails. If you do have preliminary questions, feel free to put them in the chat now. Otherwise, as we go along, you can do that. So let's get into it. All right. All right, do me a favor and put a one in the chat if you are seeing my screen, please. Let me know if you're seeing my screen. Awesome, thank you. All right. So it's a little bit about me. For those of you that don't know me, you just see this random person on Instagram or wherever you found the link. I run a law practice called Law Boss Attorneys at Law, and our mission is really to help Jamaicans at home and abroad build and preserve their legacy through real estate and estate planning. And my personal mission is that I want to be a part of the process surrounding changing what the face of wealth looks like in Jamaica and the Caribbean. I want when a woman that looks like me goes into the bank or goes into a certain establishment, there's no doubt in their mind that this person can afford to be there and is worth their time. I'm a licensed financial advisor, so I come with that lens as well. I'm also a realtor. I was formerly a youth ambassador for Jamaica and a State Department fellow. I'm a part of the class of 2018. There are two podcasts that I have. One called Legal Minute with Sophia Bryan, and the other is Driven Woman Podcast, right? So if you're somebody that likes to listen to podcasts or learns that way, feel free to look for the shows on Apple Podcasts or Spotify. All right, what you will learn. So bear in mind, folks, that this is not legal advice. I'm only able to give legal advice within the confines of a formal meeting where I know your particular and unique circumstances, right? However, we're going to be breaking down some other concepts around estate and succession, some amount of asset protection, some amount of tax avoidance strategies. Tax avoidance, of course, is different from tax evasion. We're going to look at some of the key documents that everybody with an estate plan has and how to leverage insurance as an asset protection tool. All right, so before I started the webinar, my puppy was so quiet. One moment, please. Here, one moment. One moment, please, Lord. All right, since you want to. So this is Courage, my the resident mascot. I'm going to put her away. Please give me a moment, folks. She was extremely quiet a while ago. Lord. Wow, something you just don't plan for. One moment. Let me go back to sharing my screen. All right, so an estate plan is a well thought out strategy that's unique to you and your particular circumstances. So everybody's situation is different, right? So some persons may have a family, traditional context, husband and wife, children, picket fence, puppy, um, and other people, like myself, um, professionally driven or career driven, and family may not be our priority at this time. However, it doesn't take away from the fact that you need to have your affairs in order. You need to implement certain things to ensure that what you're building is protected and you have a say over how things go over your life. I like this proverb, a good man. I inserted the word and words and woman. Leaves an inheritance to his children's children, right? This is a great proverb. Obviously, for the persons among us who are child free or children, in my opinion, can relate to having some sort of impact that outlives us. So if there's a particular cause that you have an interest in, this is that's your vehicle to ensure that you are remembered, right? So what's the cost of not having a plan, right? I'm going to share these most recent articles that came up in the media. So you don't have to do like an extensive search to see why having an estate plan is so critical. And even in instances, as we can see with, the Stuarts Empire, even in instances where a plan is done, you can have discrepancies. However, what people don't consider in that context is anytime an alteration is being done on somebody's deathbed, it's always going to raise red flags, right? So this is not unique to their circumstances. At least their family have a framework within which to handle the disputes that are arising. Imagine instances where there's no framework, there's no guide, there's nothing for the court to interpret. And I'll get to, what happens when there's nothing documented at all. This other story here, land dispute, blamed for family, triple homicide, I'll use that word. Down here, man wins 10-year battle to inherit family estate after appealing court ruling. AGD empowered to administer small estates valued up to $1.5 million. So in this situation, throughout the year, I've actually seen the ministry with responsibility for the Administrator General's department. They've actually been doing a lot of probing or prompting in the media for persons to get things in order, because guess what? When persons don't manage their estate, it's left on the government, and AGD is literally one office, and there's only so much that they can do, right? So there's been a lot of encouragement for persons to get at least a will done. And now the AGD doesn't have to wait on the court or wait on formalities for, small estates like that to be administered. And I can see circumstances where this would be beneficial, where, there may be family overseas, but there may be children involved or somebody that's, disabled or vulnerable involved, and instead of waiting on people who may not have an interest to sort things out, the AGD can handle it, right? So some other, costs associated with not having a plan. There's a risk of conflict among family members. Obviously, your wishes won't be carried out because no one will know what they are. How are your wishes gonna be carried out if nobody knows what your wishes are? The interests of your loved ones won't be protected. For those of us, that may be responsible for people who are somewhat vulnerable, your estate plan is what will put you in a position to actually ensure that those people are looked after, right? Um, your family won't have the delays if you sort things out with, accessing financing, to deal with important family matters. And then, of course, the thing that a lot of people, don't want to have to deal with, there are tax and revenue implications when there's no proper plan in place, right? So, what an estate plan is not. So, it's not just having insurance, it's not just having a will, it's not just having a savings account or an investment portfolio, or even a business, those things standalone don't help you very much. It's really giving thought to what your circumstances are, who are the people that matter to you, and how do you want to be remembered. So some persons, a will may only suffice, a will alone may suffice based on what their circumstances are. And then there are other persons who all of these things will work together in addition to having a trust in place. And of course, we're going to get into, what a trust is and how that can assist the overall plan. So what happens when you don't have a plan? What does the law say? Uh, Distribution of assets where there is no will. So what I'm attempting to demonstrate with this image is that your spouse is one of the most, if not the most important person in your life because they get the first priority to administer your estate if something happens to you, right? And Jamaica is somewhat unique in the sense that common law relationships are actually recognized by the law. So if somebody has been living together, if two people have been living together as a couple for 5 or more years, they're recognized legally as each other's spouse. And as they live together, not like a visiting relationship, they need to be under the same roof, right? But Jamaica is also, it depends on who you ask, unique or not. A lot of people live many lives, to put it mildly. So somebody may get married, when they're pretty young. The marriage becomes strained, the parties don't really deal with each other anymore. And then, they probably somebody moves out of the matrimonial home, and then they take on a girlfriend or a boyfriend that they start living with. And because of how many years that probably passed with that sort of arrangement, people start to think that that new relationship takes precedence over the marriage. No, it does not work that way, right? So if you are still married, it's the person that you're married to that's considered the spouse. And it's really for, situations like that where we would assist clients with getting divorces because, if you are estranged, if you don't necessarily want somebody to automatically inherit what you have because you're married to them, but you're not in a real bona fide relationship with them, right? So it's important for people to understand that you can only have one spouse. So if you know of persons who are in a situation where, they are living with somebody but still married, it's important that they make a decision about whether or not that marriage is going to be dissolved, or they, knowing the fact that the spouse takes precedence over everybody once they're willing, they make arrangements to make adjustments, right? I can think of a situation where I did a presentation with this was JDF at the time, and one of the soldiers stood up and he was like, Miss Brown, my stepfather passed away, and it was my mother and my sister who were looking after him. And after he passed away, his wife comes and issues them with papers and asks them to move out. And he's like, well, what can we do? And I had to break it to him that, look, there's nothing you can do, because if the wife is now asserting her role as the person with the right to administer the estate, everybody has to fall in line. And what I found curious is the fact that, he referenced the person as, his stepfather's wife. And I'm like, that means people knew that he was married, or you could speculate that people knew that he was married. And even on his deathbed, or even in his time of being sick, they didn't think that it was appropriate to put certain things in place, right? So after the spouse, you have children, so adult children, of course. Then if there are no adult children, parents can take on the role. If parents are not, don't have the capacity, or they're not around, then you have full-blood siblings, half-blood siblings, grandparents, aunts and uncles, full-blood, half-blood. So unfortunately, if you are, for example, a niece, and you're the one looking after, your elderly grandparent, not a grandparent, but like they don't fall under any of these. So like a niece or a nephew, or somebody that's referred to as a niece or a nephew, but really they're like some distant relative twice removed. Unfortunately, just because you're around, it doesn't automatically give you the right. If you don't fall within any of these relatives, then you won't have an opportunity to administer the estate. And the reality is, there are lots of people that actually don't have children. Um, and somebody is looking after them in their final days, or handling things for them, but somehow they don't formalize certain things. I can tell this story now, since we kind of on the tangent of people who don't have children. um I met it's actually my neighbor, incidentally, my neighbor's property. So this lady and her husband, they didn't have children. The husband passed away first, and then years later, um, the wife was carrying on her own. But she had a sister who has children. So her nieces and nephews, they're the ones that she left everything for, essentially, right? Um, the issue though is they can't afford to probate the will. So they have a will, but they can't really afford to probate the will. And the person who is essentially managing the property was like, oh my God, do we have to lease the property for many years before we can afford to do this? And I was, explaining to him what the possible options were. And one of the things he said was that, he wanted to say to his aunt that possibly doing a transfer prior to her passing, that would have probably saved them a lot of money, but he didn't want it to come across as though, he was pushing the envelope. And I thought to myself, well, if the conversation came up through an attorney, then it would be simply a matter of proper planning, and not praying and hoping that you pass away. So sometimes certain difficult conversations are a professional is more poised to have those difficult conversations rather than you, because it won't give the impression that you are concerned more about the asset than the person, right? So in a case like that, a trust would have been appropriate. Um, and they would have, obviously saved a lot of money. Now they're going to have to find legal fees in addition to death duties and the transfer tax associated with adding their names to the title, right? All right, so do we have any questions here? before I move on. All right, no questions so far. So we've already discussed, some of the things that come with, some of the benefits that come with preparation, peace and harmony. You can choose how your assets are distributed. Um, Orderly, order. I have been on I've done video consultations, where there's a lot of family members, and in the consultation, that's when persons are, raising the issue of, hey, I'm supposed to be paid back for this expense that I incurred to do this and that. And, they may have sort of mumbled it under their breath in passing, whether when other family members are around, but because there's no a professional in the space, they're a little bit more emboldened, and I can communicate whether or not they have, they're in a position to actually be reimbursed, for example. So yes, order is a very important thing, and helping to manage the emotions of people. Those are some of the things that, estate attorneys have to do. It is quicker to get a grant of probate than a grant of administration in the in the textbook sense, because under both circumstances, depending on the parties that are involved, if the executor is still alive, that happens. Sometimes the executor even passes away before the testator and they don't make any adjustments. So, in a textbook scenario, the grant of probate would be a lot quicker than the grant of administration, which is what you apply for if there is no will, right? Um, Very important, institutions will only communicate with an executor or trustee. The executor is named in the will and they know they're authorized to deal with this person's estate, right? So this needs more context. So if you know, for example, that there's X amount of money in a certain account, for instance, the financial institution, and you present the will, the financial institution might engage you, but they won't necessarily release funds until the grant of probate or grant of administration is provided. I can tell you about a story, a scenario where it was a vehicular, what's the word? Vehicular manslaughter situation. A taxi driver was driving very fast on the highway, and because of the speeding, it led to the death of a lot of people, including my client's son. So, I wrote to the insurance company and we're going through the motions, a lot of advocacy to get them to respond. They find an investigator, the investigator shares their findings. I send them the claim. The client's son was like 30 odd, he had a child, and I would have laid out the entire claim, right? And afterwards, when we finally settle on a figure, the attorney from the insurance company is like, oh, where's the grant of administration? And I'm just like, it's only $1 million though. I didn't write that back to say, obviously I didn't write that back, but I'm just like, it's only $1 million. Like, why? I thought that after all that we've gone through, all the steps that we've taken to get to this point, you would have had enough proof that my client is in fact this person's mother. But they're like, no. And then I said to them, we've filed the grant, the application for the grant, you know, um, and they were like, oh, they're gonna wait on the final thing. So financial institutions, are not likely to use their discretion. Okay, they are not likely to use their discretion. The only time I would say you can expect a little bit of discretion is where it's an life insurance claim, and perhaps maybe there may be some sort of complication somewhere that's preventing the insurance company from releasing the full claim, but they'll perhaps release enough to cover the funeral expenses while the administrative processes are being completed. That's the sort of discretion I've seen. Or like a retirement fund, for certain civil servants, they may not have had a will, but the person that can prove that they're the wife, they will release some of the money to cover funeral expenses until they secure a grant of administration or a grant of probate, right? So really, don't count on the discretion of any financial institution. It's really important to put certain things in place, right? And you don't necessarily have to make reference to all your accounts in your will or your trust deed. It's even more, it's smarter to indicate who you want your beneficiaries to be in the event that something happens to you. So that's something that you can do now. I know like a decade ago, the financial institutions were not giving you the option to add a beneficiary onto your accounts. You only had the option to have like a joint account holder, and some people don't necessarily want that. But you can say to them, hey, if something happens to me, these three people, these two people, this one person is entitled to receive, and you can contact them to give them whatever is in my account, right? All right, do we have any questions right now before I move on? Let me see. All right, no questions. All right, so we're going to get into wills, which is baseline estate planning. So for those of you that may have a life in Jamaica and a life in another jurisdiction, bear in mind that it's not a bad idea. It's actually a wise idea to have a will that's unique or specific to this jurisdiction, and you can have a will that's specific to the other jurisdiction. Why is this? If you only have one will, and you have assets in the States and assets in Jamaica, you have to do the grant of probate in that jurisdiction, right? And then you have to apply for what's called a resealing of the grant. So it has to be sealed. So think of like an envelope being opened. You take out some of the contents and then you put back what you're going to use for a later date, and then you seal it up back. So it's like that's sort of like the concept. So it has to be resealed, and then it has to come to Jamaica and go through the process all over again, right? So it makes sense to have two separate wills, and they have to be drafted in a certain way to indicate that, they're unique to whatever the assets are in Jamaica. All right, so we have a question here. Do you want to ask a question audibly, or you want to put it in the chat? Oh, let me see. Oh, there's a chat. Oh, there it was asked. All right. Go ahead. Janet. Please forgive me. I don't know how to. I don't know. Am I supposed to unmute?
Yeah, yeah, I'm fine. You hear me?
Okay, yes, yes, yes. Go ahead.
Jesus, what was the question I meant to ask? Oh, can you do a video? Is Jamaica at a place where you can do a video will or something like that? Can you do that?
That's a good question.
Yeah, that was
All
the
right.
question I
So,
had. I'll mute.
all right. So I'll tell you a scenario, a story about the experience I had. So in about, this is 2021, I did a consultation with a family. There's a lot of siblings. Unbeknownst to me, And I suppose, being a rookie at the time, I didn't, I was naive to think that if everybody on the call, everybody as a family is on the call, it would mean that everybody would simply honor the wishes of the person giving the instructions. Not so. So I did an interview with a family. So it was a husband and wife. They had several children and they had several parcels of land all over the place, right? Um, both were elderly. So this is a mature couple. It was understood or known that the father didn't have that much time to live, actually. So it was understood, and that was the reason behind the sense of urgency to actually get things done. And then, unbeknownst to me, there were some conflicts brewing among the siblings. So the person that had actually asked me to do the will for them, she was essentially the person that, was like the leader in the family, but there was also like a power struggle with one of her brothers. And so the video was done. It was made available to everybody. I gave them instructions about what to do to make the will valid, i.e., make sure that two witnesses sign. She was overseas, and for some reason, they couldn't get two witnesses. For some reason, only one person signed, and I'm like, I literally put it in black and white that you must have two witnesses. But for some reason, only one person signed, and I was like, okay, two people have to sign. And so even though there was a video to complement that document, because even if the will is not valid in the sense that, some of the requirements are not made, it can at least still be a part of the application for the grant of administration. So it's a grant with a will annex, even though the will doesn't meet some of the requirements. And her brothers completely disregarded what was in that video. They still ended up fighting over everything. Um, so my point is no, the video is really just there as evidence that this is in fact the last will and testament and these were the instructions. And it's really supposed to be used as like a tool to reinforce the fact that this was a person's wishes. And if it were to ever go to court, you at least have this evidence. You at least have this evidence to rely on. But the facts are as it is right now. It has to be documented. You need two witnesses. The witnesses cannot be beneficiaries. Very important. And you have to clearly identify an executor, for example. So those are the very important things, right? Uh, if you have a follow-up question to that, you can let me know. All right, question here. Is there a specific format to name the beneficiary to the bank? How will you know if they accept the instructions? Should I use an attorney to write them? No. No to the last part. No, you don't need an attorney to write to them. This is where the relationship with your bank comes into play because every bank is, unique in how they do things. So for some institutions, I know like my credit union, they have a form and you literally put the person's name and their information on the form and that's it. No stamping or anything like that is required. I suppose, when more money is involved or it's a more sophisticated sort of institution, they may say, hey, this document needs to be stamped by a JP and you might need to pay stamp duty on it and all of that, all of those fun angles. So no, you don't need an attorney to write to them. You can write your own letter. A letter like this, I'm of the view that it would be good to just do a formal written letter to the bank manager to say these are the persons, and if they do have a form or if they eventually upgrade their system and create a form, they will tell you and you just benefit from it that way. So the format is dependent on the bank. And the instruction, you just put it in writing. The only thing you have to be mindful of, you really do have to do a review to make sure that these things are up to date. All right, can wills from USA be resealed here in Jamaica? I was under the impression that it's only wills from the Commonwealth jurisdictions that can be resealed here. Um, well, that would be new information to me. I don't know that it has to do with the Commonwealth, any Commonwealth jurisdiction, because there are only like handful of handful of states that refer to themselves as a Commonwealth. I've never heard of that particular distinction before. I was of the view that it's every state, but the law evolves. All right, great questions. So let me just to recap on wills. Uh, two witnesses are required. You can have two executors recommended, as a bread and butter for a lot of pastors is being an executor. However, it's usually the older pastors that do this, and if something happened to that person, you want to have a backup. You don't need a JP to sign it. And the benefits are high. Oh, you can get it stamped with RGD if you so desire. It's not a requirement, but there have been numerous instances where wills get lost or damaged, destroyed, and it's a copy at RGD that literally prevents drama and trauma for families, Mm, Okay. Oh, well, I had said earlier you don't want a beneficiary really should not be a witness. That's very suspicious. That's just suspicious, point blank. So, nothing is wrong with asking an attorney to be an executor. Um, Just bear in mind that if you're not using a family member or a friend, the executor role is a role. And the estate may have to pay that person. But I suspect, if an attorney is offering to act as an executor, they may be making some special arrangement where the probate of the estate is concerned. But for the attorney to also be a beneficiary in their capacity as an attorney, it's a little funny there. But the rules say that the beneficiary should not be a witness. You must can find some other witness. Um, that sounds like grounds for challenge, but most definitely the registrar of the court, who is extremely meticulous, is going to raise that. Power of attorney, not something that is really talked a lot about here in Jamaica, but I've done several. Usually in the context of people living overseas, they have business to conduct here, and they may ask their parent or their spouse to be power of attorney. My position is that if you're a couple, you're married to somebody, it's probably a good idea to have power of attorney on each other, especially where your finances are mingled. If your finances are not mingled, then you may not necessarily need the spouse to be a power of attorney. It can be somebody else. Please explain the RGD getting the will. Okay, so um the Registrar General's department, they also act as there's a word for this, but they hold documents, they hold records, and the records include wills. So if you want the RGD to have a copy of your will on file, you can take it to them and pay the relevant stamp duty. And the stamp duty is based on here's a number of words, the number of lines on the page, some odd thing like that. So they literally count the words, and then they give you a fee as to what the cost would be for them to stamp it and hold a copy of it on their records. But as I said, this is not a this is not a requirement. It's just a nice to do and a wise to do. Um, Especially when you have like a lot, a lot is at stake, right? So when a lot is at stake, it makes a lot of sense to do that. So with the power of attorney, you're literally saying to the world, this person should be treated as though you're dealing with me under these very specific circumstances. The brilliant thing is with the power of attorney is you don't, persons don't have like a runway to do every single thing in your name. So when it comes down to real estate and motor vehicles, the motor vehicle has to be properly described. So the chassis number, all the identifying things about the vehicle has to be placed in the power of attorney. And where it relates to real estate, everything that describes the real estate has to be placed in the power of attorney for the person to be able to sign an agreement for sale, for example, or to execute a transaction related to those two things. All right. A story I can share with you is, this more mature lady. She at this point she's a senior citizen. However, in her younger years with her husband, they both got power of attorney on each other. By the time their son wanted to go to college, they they had to, find means of funding this and they wanted to use their real estate. Well, the mother decided that she wanted to use one of their real estate because the father was actually demented by the time their son was ready for university. So he was demented or suffering from dementia. And fortunately, she did have the power of attorney. So she was able to execute the transaction or execute the sale of the real estate without his signature because she had power of attorney. So they still had a family home, but she thought it would make sense to liquidate that additional property to be able to fund their son's education. So, she was saying to me that she didn't think that, when they were doing these things, she didn't think that her husband would, experience something like that. It was more just like a precautionary thing that they were encouraged to do, and they did it, right? Obviously, it's helpful, if you have parents and, they have a lot of things to sort out with maybe like tax office, the bank, and certain things you want to, it's easier for one person who is able-bodied to move around to get things done for them. Um, it's super helpful. But again, as with everything, you just have to be very careful. Uh, I don't know how I didn't share this story. Before before we move on. So on the note of spouse, right? So it's not just about how you say, it's not just about, when you ride off into the sunset and who is managing your affairs. You have to, where your spouse is concerned, you have to think carefully about who is going to be responsible for dealing with things for you when you're incapacitated or some, vulnerable. And the story that pops up in my head is this scenario where an elderly person, when I say elderly, I'm talking late 80s, going on to 90s, got married to their helper slash nurse slash whatever you want to call it. And the family essentially just left everything up to the nurse to look after the man. This man had acres upon acres of real estate. And somehow the nurse was able to get married to him. And in the sale of a lot of the parcels of land, she was the one that signed over everything, signed for everything, signed, to acknowledge receipt of everything. And the document that the attorneys used to justify that was an authorization letter in her capacity as spouse, she can, sign on his behalf. So the power of attorney situation is definitely something that needs to be considered. But if you have elderly parents or elderly people in your family, don't just leave them up, to the nurse or a caretaker or whomever. I also have this other scenario where child-free woman, she was in a nursing home in the States. The nurse or the primary nurse that was responsible for her somehow found out that she had land in Jamaica, and somehow that woman became her administrator for her estate when she passed away, and sold the property that she had in Jamaica for like under market value. And then when my clients found out, it would have been a lot of time would have passed and the transaction would have been done. New owners start building on the property, which is how they found out that the property was actually sold, right? So be careful be careful to show some care to your elderly people because they're very vulnerable at that stage. Healthcare powers of attorney. This is not necessarily something that's popular in Jamaica, but this is something that you can explore. And you can also be mindful of the fact that if you have a primary healthcare provider, you want to ensure that you have something on file to indicate who your next of kin is. So who the hospital or the doctor can call if anything were to happen to you. So in lieu of a healthcare power of attorney, you want to ensure that your next of kin is stated on file, and if you have unique needs, you communicate that in writing to the hospital and communicate what and what they can and cannot consent to on your behalf. I think we've discussed grants of administration versus probate a little, somewhat extensively. Um, almost it's 8 o'clock now, guys. All right. So grant of administration is what is applicable when no will is involved, and a grant of probate is, what happens when there is a will and you're going through the process to administer the estate. So just a little bit quickly here, in terms of tax avoidance and succession for persons who do have companies or businesses. Depending on the size, you want to ensure that there's some sort of board of directors in place. There's some sort of documentation. There's something in place to communicate the transition of power, right? And it needs to be communicated, the CEO, for example, what's going to happen to his shares or her shares? If something happens to her, is it going to go back to the company or is it going to go to her or his spouse? And, not figuring those things out can have serious, tax implications and implications for whether or not the company can actually continue, right? So persons who manage a team especially have to take into consideration these things. So trusts, these are particularly helpful so that we avoid probate. So for many people who have anything, any major assets, it's usually real estate. Transfer tax is 2%, right? So if you have a $50 million property, for example, what's 2%? So 2% of, and we hope the government doesn't change this because at one point it was actually 5%. So 2% of 50 million is $1 million Jamaican dollars. That's what the transfer tax would be on that sort of asset if you're moving it from one beneficiary to the other. And there's also death duties, and then there's also, legal fees. You're able to cut out all of that if a deed of trust is established to say, this is the real estate that we have, these are the beneficiaries. of the real estate, and this person is a trustee. You as the owner, in where real estate in Jamaica is concerned, you'd be the trustee, and that would be communicated to the relevant institution that has the mortgage on the property, as well as the National Land Agency, because that is something that is kept on record with them, right? So the big push with having a deed of trust established, other than the privacy of how certain assets are going to be distributed, you avoid a lot of the fees associated with it. So, for example, if it's already known or clearly established that, look, when so-and-so passes away, the children have the freedom to sell the property rather than having to go through the process of getting a grant of probate. This particular property is already set up under a trust, and so they can just go to market right away, find a buyer, and execute the transfer instrument, right? No fuss there. It's also helpful when it comes on to families that may have vulnerable persons that they're looking after. So if you know, for example, you want to ensure that there is continuous revenue or continuous income, and you put certain financial instruments in place, you want to ensure that there is somebody responsible for managing this. So you don't want it to go through any sort of, you don't want something like that to be recorded in a will, because the only thing the bank or the financial institution is going to do is just to simply hand over the money to the executor. But what if you said, look, if I'm leaving $10 million in this account, I want um, my puppy, for example, to be looked after for the duration of her life. And whatever the interest is, my trustee has the right to withdraw that money and use it to take care of my puppy, right? So, whereas if it was recorded in the will, the money would simply be transferred over to the executor, and then the executor, in their own discretion, would do whatever they feel like they wanted to do with the money, right? So that's how you have control from the grave. You get to put, whatever rules surrounding how your monies or how your assets are going to be managed, whether or not you're here. Right. How is the trust deed validated? Great question. So it has to be stamped. And then it also has to be given to the National Land Agency. So it has to be, so essentially it's two documents. So one, if you have multiple properties, for example, you want that to be recorded in one trust, but a separate deed has to be presented to National Land Agency, has to be stamped and presented to National Land Agency to communicate that these properties are under trust. No, you're not going to get a new title, and it's not necessarily going to be recorded on the title that you have. Your title is still going to say, Mary Brown. But if somebody goes to try and sell the property or do whatever or investigate, um, land agency is going to be like, oh no, this property is actually under trust. And they're not going to say who the beneficiaries are. The beneficiaries need to know themselves, right? But nothing can be done outside of these people, right? So say, let me make this clear. So say, let's hit at the men with double lives. So say somebody with a double life has like three pieces of property, right? The wife knows that the person has three pieces of property, right? After all, she helped to buy them. But maybe the first property only has his name on it because they were only boyfriend and girlfriend at the time, and she couldn't sweet him up enough to add her name to the title. So she, gets her grant of probate and is now trying to sell the property, and National Land Agency is going to be like, hold up, yeah, no, this property is actually under trust. And that's how she's gonna realize that that property has already been handed over to maybe the secret love child or something like that, or maybe a sister, some long lost cousin. they're not gonna, as far as I'm aware, they're not allowed to communicate who the beneficiaries of that trust would be. They would just know that, communicate that, hey, nothing can happen with this property because it actually does not fall under the estate of that person. What if there's no property, just billions all over where you lodge it? So again, each financial institution has their own nuances and their own rules. So if it's just money, like, capital markets accounts, money in different bank accounts, you have to figure out from the financial institution what information they would need in order to transfer ownership onto the trust. But for me though, just from like a position of just making life easier. If you know that, okay, I'm setting up this trust, I have three, four, five beneficiaries who I want to be able to benefit from the money, rather than making the attempt to transfer the ownership to the trust, I would just create new accounts altogether in the name of the trust. I think that would actually be a lot easier, less messy to do. But again, it boils down to the institution that you're dealing with, and how easy it is for them to facilitate that process. But, after giving it some thought, um, I think you should just create new accounts in the name of the trust and then just move that money. If you're not gonna be, if your compound interest is not gonna be affected, which I suppose that would be the downside, because the moment you move the money, like for example, like a repurchasing agreement, the moment you pull the money, it stops. That recurring rollover interest that you'd get would stop. So really and truly, before you make certain big decisions, you really need to give it some thought and process it. Um, I would say. And the reason why you would want a trust if you have money, I don't know that you can give the bank any instructions to hold on to the money or to use it in particular, sir. I don't know that you can give the bank those instructions. You can only tell them that, look, if I'm incapacitated or pass on, I need these people to get the money. I don't know that you can give them any additional instructions about how you want the money to be spent. That's where the trust would come into play. Sure, go ahead, Janet. Think you can unmute yourself for
Yeah, quickly. I just wanted to that thing. I think I missed what you were saying a while ago about I was just asking under what circumstances can you create and what accounts are you talking about? Is it bank accounts in relation to a trust? Let's say I have a house. Can I move the house to the trust? Or would need to meet for you to tell me what and what and what I can put in a trust and how much
so
money,
really
because you were saying about people having money. So what do you consider money in terms of creating a trust?
okay. So when I brought up the issue about money, somebody asked the question, what if there is no property, just billions all over? Where do you lodge it? So they were asking about what would happen in a certain situation like that. And I was responding to say that, um, lodging the trust with the financial institution would be dependent on what their formalities are. So for some institutions, you can present the deed of trust and transfer the assets into the trust name, and then all the rules that apply when you're setting up the trust would follow thereon. Um, but then and I was saying it may be more practical, if you're not going to be financially affected, to just create new accounts in the name of the trust and move your assets there, i.e. financial instruments and so forth. As it relates to what assets can go into a trust, it really just depends on you, what you have and what you want to do. So it can be real estate, it can be EFTs, it can be, cash liquid. It really depends. It really depends on you. All right, so for clarity, I need multiple deeds specific to each institution that holds my property or funds. When I spoke about having more than one deeds, I was speaking to real estate. So you have one trust, and if you have several real estates, you would need a, a deed that speaks to that particular piece of land that connects to that major trust, right? So you're not going to present this big document to National Land Agency. You would just have one thing that probably has one or two sheets to say, this is my deed of trust, and it would mirror what's in your main trust that has other assets that are placed in it. So again, it really boils down to what your circumstances are and what you want to do, right? So the trust needs to identify the property or properties that you want to put in there. You need to identify a trustee. You can be the trustee. Our law says that you should really have two. However, the law also says that if you only have one trustee, it doesn't take away from the validity of the trust, right? So some people want to maintain control. But in the event that something happens and then there's no trustee, then really all the beneficiaries, hopefully, they know that they're beneficiaries, and then they would be guided based on what the terms of the trust, what the terms are. And if needs be, the court will intervene, particularly if there are minor children involved, the court and or administrator general would get involved. This kind of has, almost go without saying, who is the trustee? The trustee is really the person or entity that is responsible for ensuring that the rules set out in the trust are followed. So it's a fiduciary duty, right? So you have trustees that, they charge an annual subscription. So every year, some amount of money from the asset pool is paid to that person to manage. Some people charge a flat fee, some people charge a percentage. Um, so it just depends on the person's circumstances. But it's perfectly fine for you, the owner of the assets, to act as a trustee if you are okay with if you're not particularly concerned about that, privacy issues. Yeah, but it would be, if there is a mortgage on the property, can it be placed in a trust? Yes, but obviously the trust would be subjected to that mortgage. So the mortgage company would have first right. Okay, you have to clear your debts. All right. So how does a trust work? I think I had extracted this from the legislation. No, I didn't extract this from the legislation. I extracted this from, should I put the name of the book there? But anyhow, um, this is extracted from a book from one of my lecturers in law school. So the main characteristic of a trust is that the trust property is vested in the trustees, not for their own benefit, but for the benefit of the beneficiaries. Right? So instead of giving the property directly to the beneficiaries, the donor's purpose may be to donor is means the same thing as grantor. So if you say the word grantor is the same thing as donor. I think grantor is more popular in American language. The donor's purpose may be to be more effectively carried out by appointing trustees who will not only safeguard the property and apply it in the manner directed by the trust instrument, but will also make it productive. For example, in the case of land, by letting it, or in the case of money, by investing it in shares or securities. So the upside, as I was saying, is that look, if you only have a will, The only thing the grant of probate is gonna do is gonna say to the court is gonna give the person the grant, and then they just get the money or they just get the property in their name. And then it's up to their discretion what they want to do, obviously after clearing debts. Whereas if a trust is established, you already set the rules about what they can and cannot do, right? So it's not left up to their discretion. And then if something happens to the trustee, you've already specified in the trust how your money is supposed to be spent, maybe what instruments you want to invest in, etc. So in most cases, trustees are not merely passive custodians of the trust property, but active business people responsible for ensuring that the property bears as much fruit as possible for the beneficiaries. So you really have to think carefully about who you want your trustees to be. If you still want to maintain that control where you are going to be one of the trustees, you want to ensure that you are as detailed as possible about how you want things to be operated. What about trustee and executors do not carry the wish of the person? Also, what is a living will versus a living trust? I don't know what a living will is. I think that's just something people make up. But when people speak about living trust, essentially the idea is that the trust is still alive and active while the grantor or donor is alive. So in the case of, where you're investing money actively, you're actively in control of the assets, whereas you have some trust where, give me a moment, please. Let me just take a sip. And how do I turn off the camera? Sip. All right, and I'm back because my throat was starting to get dry. I think there are still some important things on the slides. I'm going to share my screen again. Right. So there's no living will thing. I don't really. It's something that people make up, but the living trust is another make up thing. But essentially, the idea is that everything that you have in the trust, you still have access to it. You can still manipulate it. The rules are where you've established that. Whereas there are other trusts where it only takes effect upon the passing of the grantor. So benefits, I have in bold here, avoid or minimize taxation. And I say minimize too because you have to pay taxes on everything. So if you have money in a financial instrument, for example, um, and you decide to pull it, taxes apply, right? But at least, the whole issue, the taxes associated with probate, they won't apply. For child-free people, this is important. I mean, question, can the trustee be the sole beneficiaries? People do that. People do that. But I imagine you want to have some other contingencies in place. Um, you might want to have some other contingencies in place. Because if you're the only beneficiary, what's the point of creating a trust? Because you just utilize your money how you want to use it. I guess for, people want to maintain privacy, there is that benefit. So I take that back. Some people just want to be very private. They don't want anything in their name, so they'd prefer to do that. Uh, but other benefits. So yeah, I was saying for like child-free people, maybe there's a cause that you're interested in, maybe your alma mater. You wanna maybe you wanna establish a charitable trust. Maybe you have siblings, maybe like me, you're a dog mom. You want to ensure that nothing your dog is taken care of. There's so many things you can do. It's not, a legacy is not just children. And I think a lot of people feel that because they don't have children, they don't need to do these things. But you have a full life, and you just need to get creative. The way how things are going now in terms of access to information, technology, nobody typically just has one job. Even in my law practice, I have like three main practice areas, and sometimes it feels like three different businesses, to be honest. And so the earning potential of a lot of professionals now is really, it's a lot more expansive than it was before, even 5 years ago. And so it's highly unlikely that you're going to spend off all your money while you're alive. So you want to give some thought about, what you're doing with it if you don't end up having children. So you can create charitable trust, and everybody knows about Wolmers. Wolmers is a charitable trust. And their thing is the schools, right? All right, so how do you fund your estate? How do you fund your trust? We can talk about life insurance. So this is particularly helpful for those of us that do have children and you want the payout from the life insurance policy to just go directly to the trust or be placed in a trust. And then you can create rules around how that money is spent. You know what, if you have $100 million policy, you don't necessarily want to just hand over that money just so. You can probably, put certain things in place where whatever the payout is, you could probably make the trustee be the beneficiary of the life insurance policies. And then, of course, the trustee has to operate in a certain way based on what your deed of trust says. Um, I don't know that I don't recommend putting the life insurance policy in a trust because life insurance institutions sort of have a way of doing things administratively, and you don't need to add that layer of complication if it's not necessary. You can just simply indicate to whoever you're making the beneficiaries, you indicate what the instructions are to them, what they can and cannot do to the money, or they lodge it in their account or what have you. Which is again why you do need to trust somebody. You do need to, ensure that you select people that are gonna honor your wishes. But then it also boils down to, if you're creating a trust, you want your beneficiaries to know who they are, so that, if needs be, they can advocate. What are the legal implications for the trustee settlor if the property assets is extinguished and if there's nothing left for the named beneficiaries? Extinguished by whom? If they extinguish it, I mean, they can't, if it was due to the irresponsibility of the trustee, then the beneficiaries can sue them. So insurance can use that as a great way to fund your estate. So you make sure that there is money. You can look into pooled funds. If you're like me, where you prefer to take your time and identify your individual stocks, but you still want the benefit of investing. So you buy into different instruments where multiple stocks are traded. And you have quite a few in Jamaica. A lot of the financial institutions now, like the brokerage houses, they have their own funds. So that's where they identify stocks all over the world. And then they put money in those funds, and then you get a return on that. Still very expensive to participate in a lot of those options. But I know that Jamaica National, for example, has a mutual fund, and it's extremely affordable. Don't know if it's performing well right now though. Can't speak to that. Jane is not generally doing well, but hopefully they rebound. uh You have the life insurance companies, so Sagicor as well as Guardian Life. Um, I think I think Kuna is an independent company. I'd have to, I should probably check that out. I'm not sure if Kuna does health as well as life. And then there's an international company that's operating in Jamaica now. So the point I'm making is that the insurance companies also have investment instruments that you can take part in, and they're also very affordable. The downside is for people that don't like commitment. A lot of those products you have to commit to like a 10-year period. But as far as I'm aware, if you do decide to close the policies like midway, you still have a decent amount of money to look forward to. As long as you go beyond like 24 months, you should see a decent return on your money. So those are things you can look into. Less risk in the sense that the insurance companies are backed by a lot of money. And they've tried and tested the funds that they participate in over the years. So they're a little bit less risky. But again, if you're going for the more high level products where you have to have like 500,000 JMD or a million JMD, anything over $1 million, you start paying taxes on that, unfortunately. I'm hoping that the government makes adjustments to that soon because obviously $1 million 5 years ago, 10 years ago is not the same as it is today. Uh, Another way is to really, I don't have it here. Oh, I do have it. Participate in a retirement scheme. If you're with a company that matches what you pay, take advantage of that. Um, those are, that's some to an extent that's tax-free money as long as you don't pull before your retirement. There are some tax advantages there. And you find ways to spread your risk, of course. We talk about insurance. So why it's a great tool in terms of protecting your assets. As I spoke about, the 2% transfer tax. If you create a life insurance policy that not a premium, the payout covers what you anticipate to be all of your expenses to do probate, for example, because best believe, you still need a will even if you're doing a trust because you need something that acts as a catch-all in the event that you get a certain asset before you get an opportunity to add it to the trust, for example. If you end up still having to do any form of probate, at least you have a decent amount of money to cover those expenses, right? So it protects it in the sense that your family is not going to have to sell or liquidate anything in order to um, cover the taxes or fees associated with owning some of your assets, right? Um, so just a basic things to consider when you are preparing for a conversation with an estate attorney. Um, Review your life insurance policies. I always encourage people, look, if you had a policy and you may have stopped paying on it, but there's a way to revive it. If it's an equity linked policy, if it's like a coupon policy where there's no savings attached to it, maybe let bygones be bygones. But if it's an equity linked policy, and you can reinstate it, I encourage you to do that. If you can increase it, consider that. If you don't have life insurance, gonna share this tip with you. Get the most that you can get because as we get older, it becomes more difficult to pass a medical. They're extremely critical about your health situation, your BMI, if the pressure not, something off on the day that you decide to do your medical. So the younger you are, presumably the healthier you are. So you want to get the most that you can afford to get. And bear in mind that you do have the option to increase every year, but your increase is capped at up to 20% right now. So you can't increase it by more than 20%. And depending on the direction that your life goes into, you want to have the option to increase, right? Um, and then just on the note about insurance again, you're supposed to be able to request our annual review with your advisor, or if the person that sold the policy doesn't work at the company anymore, there is somebody that you can speak to. And yeah, so that's it. That's it, my tips there where life insurance is concerned. Get as much as you can get while you're able to. Oh, one more point. So there was a time, that time exists no more. There was a time when what's the word I'm looking for? You have short-term policies. So if you are getting a mortgage, for example, and the mortgage is lasting for 30 years, and you just say, you know what, I'm just getting a policy for the duration of the mortgage. There used to be a time when that life insurance was a lot more affordable compared to the policy that you'd have for the duration of your life. They're kind of neck and neck with costs right now. So again, if you're presented with the option to get a term, it's called a term policy versus a whole life, compare the numbers. So especially if you're going into a mortgage and you need to get the life insurance, just compare the numbers. Very, very important because insurance has gotten a lot more expensive over the years. Wills, if based on the circumstances, there's no need for you to get a trust, you do want to ensure that you make certain provisions in your will if you have minor children. So some kind of trust provision to say, Mary Brown is going to be responsible for John Mark, until the age of 18, and that person would be responsible for whatever John Mark is supposed to get. Audit your assets and give considerations for any plans that you may have around real estate acquisition. And so I mentioned the life insurance a bit earlier, as well as you want to also consider how easily accessible your money is. I feel like I've given enough examples about child-free people and the fact that you still have things to do even if you don't have kids. All right, so some next steps that you can consider. I want to invite everybody here to consider doing an annual review with me. So this is typically something that I offer to my premium clients, where by the time it gets here, we would have had multiple conversations. But this is more like structured time to figure out, how they want to refine things, if you need to make adjustments to any documents, if I need to write to any institution on their behalf, if there's anybody they need to add or remove to their will. We review everything and we come up with the best strategy based on what their circumstances are. Why I'd encourage you to get this now. This may not be applicable to everybody here, but you can stop sharing my screen. If you have an outdated will or trust, we can review it. If your beneficiary designations need to be amended, if you have any contracts pending and you need insight there. And if you are going into business, you want to consider what are the implications for that with your family. Just to say here, I've had conversations with persons or strategy sessions with people who are typically on the more mature side, and I find that we come up with a plan of action and then they stall the process because somehow, it's like mortality is staring them in the face. And I really just think it's a mindset issue because the reality is we know that, that day is gonna come one day, right? Um, So you can't, who keeps the main deed? So it's really just a mindset thing. All right, question of who keeps the main deed. The trustee would have a copy and the grantor would have, it would just be put up somewhere safely. We don't have a record in Jamaica right now, but it would still be stamped. Um, Stamped by RGD, but the main deed, you get to decide who you want to keep that, but most likely a trustee would be the most appropriate person to do that since they're the ones that will be carrying out your wishes. All right, any other questions? Since we're on the finishing, feel free to share any other questions that you may have. So just to go over what we can discuss in the review session, we can look at what the estate plan needs to entail. As I mentioned before, we can do a review of what you have existing. We can look at any pending transactions you may have. If you have any probate matters, you know, so many people tell me about, their parents having, to probate should have been done 20 years ago and they don't know what to do and it's complicated. We can discuss those things. If you're a business owner and you want to consider anything related to like industrial relations issues, we can look into that as well. And then personalized recommendations. So I can look into, just from my insights as a financial advisor, different things that you can explore. I find that a lot of the different instruments that you can explore, they're not necessarily widely publicized. They're usually left for persons who have a certain net worth, but if you ask the right questions, you may be able to get access to certain opportunities, even if you don't have a massive net worth, right? So I bring that lens as well as to what you can explore. So it's not just a generic consultation, it's more of like a high level strategy, so that you don't have to, deal with some of the things that certain people have to deal with now, the fatigue around, the costs associated with doing probate and whether or not they have to rent out the property to be able to afford it, that's a hot mess kind of situation. Uh, so if you bought real estate in the last 2 years or you're thinking about real estate, or you've accumulated new assets, any major life changes, so like, you got married or you're planning to get married, it would probably be helpful too, figuring out how to manage resources in the context of a marriage, and what opportunities they can explore, right? So if you want more structure going into 2026, I think doing the session is appropriate. So for me, why work with somebody like me? So just my experience over the years has allowed me to see various scenarios and various circumstances. And so having the training in finances and then of course real estate, I can give you more insight as opposed to somebody who just does law alone or only has exposure to law only, right? And the main aim is to prevent any sort of dispute and, put yourself in a position to make smarter decisions, right? So the session is typically $500. For the persons who join the live webinar, it's being offered at $397. These annual reviews, obviously are applicable for the month of December, going into January. For the persons who are live, you have the option to book a slot at this rate. And then after 72 hours, 3 days, and I will be removing that link from the platform. So I'm gonna stop sharing my screen now. So I'm gonna share the link in the chat. If you want to grab a spot, you have the option to do that. And then for those of you who may want to catch the replay, of the session. I'm also going to put the link for you to be able to purchase the replay as well. So you can copy and paste that before we head off. Go ahead, Janet. Or did you want to type in the chat? Wait a minute. I use Zoom so often, and then I always seem to see something that I'm not familiar with. Anyhow. All right. So before we go, any other questions? Do you cover U.S. jurisdictions? I'm not sure what you mean by that. What do you mean? Okay, go ahead and unmute. Oh,
Oh, I
okay.
just realized I wasn't, I just remembered. So question, the question I want to ask, let's say you're married to somebody and the person receives property through, the person left property for them in a will, your
Yes.
husband or your spouse or wife, whatever, and your spouse, and they left the property and the spouse dies. Um, if they left a will saying who they're leaving the property to, the spouse gets nothing. Is that how it works? So let's say I have a house. We have a house, and let's say the spouse dies. One of the spouse dies, but let's say the spouse's sister willed a property to the spouse. Let's say they willed a property, and then your spouse dies. But your
Mhm.
spouse left a will, and in the will they said, okay, I'm just going to give that property to my brother or to
Okay,
another family
understand. So the
member.
spouse is written out of the will.
So the spouse is written out of the will. Okay, all right, I understand now.
So in a
Yeah.
situation like that, the only thing, I mean, it may be worth the effort to challenge it. Um, because maybe, well, I suppose it would be like, if you can look at the date that the will was done, versus when they got married, if that will was done after they got married, um, I'm sure there could be ways to challenge it. Um, but people write their spouse out of their will all the time. It does happen. But where it's a case where your intention is to prevent there being a challenge, you can probably leave the person like a nominal sum. Oh, they're not written out, they're just not benefiting from the property. That's what you're saying? Well, if they were given something, but they just weren't given a share of the main asset, then to me that clearly indicates what the person's wishes were. But at the end of the day, you can't decide if you want to, well, they can decide if they want to challenge the will or not. In terms of other jurisdictions, so my license only allows me to give instruction, take instructions with respect to this jurisdiction. However, I can give recommendations about what to do in the US. There are some things that apply regardless of the jurisdiction. So, for example, with your will, almost every jurisdiction requires two witnesses, right? Two witnesses are required. Can't have a beneficiary being a witness, it just looks suspicious. Uh, and in the case of America, a notary has to validate that they've seen the ID for the person that's signing as a witness. So that's the main difference there, between most states in the US and Jamaica. So the two witnesses are required, but then a notary also has to sign, for example. Right. So if probate would have to take place in the first estate that holds the property, probate would have to take place. So there's no going around it. Probate would have to take place in both estates. And yes, the executor of that, the first will would be required. No, I'm not. No, that's what I'm saying. I'm only licensed to practice in Jamaica. I can only give recommendations with regard to the US and then um make recommendations to counsel in the US. All right, so it's we've gone closer to 2 hours. So again, the link to the replay is available to those of you who want to be able to have access to the replay, and the link is also there for you to schedule a review session and to develop your own plan of action going into the new year. So if you want some legal strategy and insights, you can do that. I've also shared my Zelle. So if you want to pay the $67 for the replay via Zelle, or you want to pay for your session via Zelle, my Zelle information is also there that you can copy. All right, so you've been a very attentive audience. Thanks for the questions that were asked. Okay, so I'm gonna share um, I'm going to say 876 and 6508. All right, so I shared the contact number for the office. Miss Eccles will assist you with setting up a time to meet, but I can also go ahead and share the link for a 30-minute call. One moment. All right, so the link for a 30-minute call is there. So if you just have like one or two questions that you want to power through or get some guidance on, you can schedule a 30-minute call using that link. If you need to ask more questions before you go ahead and book a consult or book the session, the review session, you can call or WhatsApp, and Miss Eccles will assist you. So the number is there as well, 339-6508. All right, so I'll just be up for another 2 minutes. A person can just copy and paste the links. And then I'll close out the Zoom. All right, glad you got some value from it. Please spread the word. When you see my videos pop up on Instagram and LinkedIn, please share them. Thank you. Good evening, folks.